Hi, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Today we're going to take a look at a recent case from the United States Supreme Court. It was decided this last week. It did not get a lot of attention in the media, but it did get a lot of attention from lawyers. It's called Mallory versus Norfolk Southern. Yeah, that same company that spilled all those chemicals in Ohio. So, with that in mind, stick around. We're going to talk about that with a little history. So, one of the things that I think is important in understanding this case is getting a little bit of a flavor of the history of it and the law behind it. First of all, there are, for the purposes of this discussion, two main types of jurisdiction. One of them is subject matter jurisdiction, and that is the power of the court to hear the case. And the other is personal jurisdiction. Does the court have the power to bind an individual to the judgment? In other words, the court has to have power to bring that defendant in and issue a judgment that will bind them in the case. And if it doesn't have personal jurisdiction. So, looking at subject matter jurisdiction, federal courts are courts of limited jurisdiction. They are authorized to hear cases that involve federal questions. In other words, whether or not some section of the Food, Drug, and Cosmetic Act is applied correctly, or whether the ATF violated a rule by issuing a regulation. Those are federal cases. Those can't be heard in state court because the federal court has exclusive jurisdiction, at least over those two. Then you look at diversity jurisdiction, which is also available to you in federal court, and that is a suit between citizens of different states. So when one person is in Alabama and another person is in Florida, the Alabama person can sue the person in Florida with no problem whatsoever. That's just the way the law works. And they do it in federal court. Subject matter jurisdiction. The court can address the issue, the subject matter of the particular lawsuit. And with regard to personal jurisdiction, let's suppose you have a situation where somebody's driving through Iowa and they eat at a restaurant called Last Week's Seafood, and they get last week's seafood and they get food poisoning. And by the time they get to California, which is where they're heading, they are really ticked off and wiped out as a result of having had food poisoning. So they decide to sue in California state court the restaurant in Iowa. Well, if the restaurant in Iowa doesn't do business in California, doesn't buy supplies from California, has no contacts with the state of California, then the California state court is not going to have personal jurisdiction over that particular defendant. So that's a little bit of an understanding of how those two work, but also it's important to understand what can be waived and what can't. So subject matter jurisdiction can never be waived. In other words, if a court does not have power to render a judgment, that is something that you can bring up at any time. You can even wait until you're on appeal to say, hey, guess what? The court never had jurisdiction. And in fact, I've seen lawyers recommend that people do that, let somebody waste all of their time and money getting a judgment and then going through to the appellate process only to find out that they just wasted that money because the court that they were in did not have jurisdiction. Even though subject matter jurisdiction cannot be waived, personal jurisdiction can be. Personal jurisdiction can be waived in a couple of different ways. One way is by consenting to suit. For example, if you sign a contract with Verizon or AT&T or T-Mobile or any of the carriers, one of the things that their contract most likely requires you to do is to consent to judgment in wherever their headquarters is. Now, why do they do that? Well, where do you think the jury pool is going to be drawn from in a case like that? Of course, it's going to be drawn from their home area. and those folks may have a vested interest in making sure that that company doesn't do poorly. It's one of the reasons why federal courts are important, because they give the defendant, a foreign defendant, an opportunity to go into federal court. And of course, frankly, many of those also contain arbitration provisions, which would keep you out of court anyway. But as an example, that's a good example of what consent means. And then waiver is where they do not have personal jurisdiction and your lawyer doesn't raise it. In other words, he answers the case substantively or files a motion to dismiss that leaves that claim out. Well, you've just consented to personal jurisdiction in that area. And that is never a good idea. So let's take a look at probably the most recent personal jurisdiction case, pure personal jurisdiction case, and then we'll move on to Mallory. This is one of the more recent Supreme Court cases that dealt with the issue of personal jurisdiction. It is Bristol-Myers Squibb versus the Superior Court of California. And essentially, Bristol-Myers took this issue up to the Supreme Court, and we'll see why here in just a second. A group of plaintiffs, most of whom are not California residents, sued Bristol-Myers Squibb in California State Court, alleging that the pharmaceutical company's drug Plavix had damaged their health. BMS is incorporated in Delaware and headquartered in New York, and it maintains substantial operations in both New York and New Jersey. So, looking at that, we know that they could be sued in Delaware, New York, and New Jersey with no trouble whatsoever. Although it engages in business activities in California and sells Plavix there, BMS did not develop, create a marketing strategy for, manufacture, label, package, or work on the regulatory approval for Plavix in the state. And the non-resident plaintiffs did not allege that they obtained Plavix from a California source, that they were injured by Plavix in California, or that they were treated for their injuries in California. So the California Superior Court denied their motion to quash, and they took that up through a series of opinions up to the Supreme Court. And the primary concern in assessing personal jurisdiction is the burden on the defendant, and settled principles of specific jurisdiction control this case. For a court to exercise specific jurisdiction over a claim, there must be an affiliation between the forum and the underlying controversy, principally an activity or an occurrence that takes place in the forum state. So that was the rule that was laid down in Bristol-Myers Squibb, and it has been used quite handily by lots of defendants to get out of both state and federal court in a distant jurisdiction in order to require the other party to sue in their home jurisdiction. So no two cases are ever the same, and you wouldn't expect them to be. But the principles that are announced in one case you would expect to be applied in yet another case. And that's important because that's how cases get decided. It's called precedent, and generally speaking, you take the facts of one case and you analogize them to your case and you say, this is why you should rule this particular way. And unfortunately, or fortunately, depending on which line you come out on, you could very well have an incorrect assertion, or the court could say, no, that's not what we meant in the prior case. And I think what you'll see here is that's very much the case. In this case, you have a plaintiff who lives in Virginia, but who has lived in Pennsylvania, and who, when he worked for Norfolk Southern, worked in Ohio and Virginia. And he developed cancer and he sued his employer. And basically, as a result of suing his employer, the employer went to the court in Pennsylvania and said there's no personal jurisdiction. And indeed, the personal jurisdiction analysis in the Pennsylvania Supreme Court, applying Bristol-Myers Squibb, they said, yeah, you're right, it's not consistent with due process. So there's no lawsuit. Let's take a look at how Justice Gorsuch frames the issue in this case. From the syllabus of the case, Robert Mallory worked for Norfolk Southern as a freight car mechanic for nearly 20 years, first in Ohio, then in Virginia. After he left the company, Mr. Mallory moved to Pennsylvania for a period of time before returning to Virginia. Along the way, he was diagnosed with cancer. Mallory sued his former employer under the Federal Employers' Liability Act. He filed a lawsuit in Pennsylvania State Court. Norfolk Southern, a company incorporated in Virginia and headquartered there, resisted the suit on the basis that a Pennsylvania court's exercise of personal jurisdiction over it would offend the Due Process Clause of the 14th Amendment. When the complaint was filed, Mr. Mallory resided in Virginia. Mr. Mallory was exposed to carcinogens only in Ohio and Virginia. Norfolk Southern manages over 2,000 miles of track, operates 11 rail yards, and runs 3 locomotive repair shops in Pennsylvania. In fact, Norfolk Southern has registered to do business in Pennsylvania in light of its regular, systematic, and extensive operations there. And Pennsylvania requires out-of-state companies that register to do business in the Commonwealth to agree to appear in its courts on any cause of action against them. By complying with this statutory scheme, Mr. Mallory submitted that Norfolk Southern has consented to suit in Pennsylvania on claims just like this. Now, what's interesting here is that Judge Gorsuch announced the opinion of the court in Parts 1 and 3B, in which Thomas, Alito, Sotomayor, and Jackson joined, and an opinion with respect to Parts 2, 3A, and 4, in which Thomas, Sotomayor, and Jackson joined. Jackson filed a concurring opinion. Alito filed an opinion concurring in part and concurring in the judgment, and Barrett filed a dissenting opinion in which Roberts, Chief Justice, and Kagan and Kavanaugh joined. So this is what we would call a fractured, one might say badly fractured, opinion. But here's how Justice Gorsuch starts us off. Imagine a lawsuit based on recent events. A few months ago, a Norfolk Southern train derailed in Ohio, near the Pennsylvania border. Its cargo, hazardous chemicals. Some poured into a nearby creek, some burst into flames. In the aftermath, many residents reported unusual symptoms. Suppose an Ohio resident sued the train conductor seeking compensation for an illness attributed to the accident. Suppose, too, that the plaintiff served his complaint on the conductor across the border in Pennsylvania. Everyone before the court agrees a Pennsylvania court could hear that lawsuit consistent with the Due Process Clause of the 14th Amendment. And the court could even do so if the conductor was a Virginia resident who just happened to be passing through Pennsylvania when the process server caught up with him. Now let's change the hypothetical slightly. Imagine the same Ohio resident brought the same suit in the same Pennsylvania state court, but this time against Norfolk Southern. Assume, too, the company has filed paperwork consenting to appear in Pennsylvania courts as a condition of registering to do business in the Commonwealth. Could a Pennsylvania court hear that case too? Well, you might think so, but today Norfolk Southern argues that the Due Process Clause entitles it to a more favorable rule, one shielding it from suits even its employees must answer. We reject the company's argument. Nothing in the Due Process Clause requires such an incongruous result. The court goes through a lot of the history and begins talking about tag jurisdiction, or what it calls tag jurisdiction, from a case from 1990, Burnham versus Superior Court of California, County of Marin. The case began with Dennis Burnham's business trip to California. During his short visit, Mr. Burnham's estranged wife served him with a summons to appear in California State Court for divorce proceedings. This court unanimously approved the state court's exercise of personal jurisdiction over Mr. Burnham as consistent with the Due Process Clause, and did so even though the Burnhams had spent nearly all their married life in New Jersey and Mr. Burnham still resided there. Unsurprisingly, corporations didn't relish the prospect of being hailed into court for any claim anywhere they conducted business. No one, after all, likes to greet the process server. Corporations, however, chartered in one state sought the right to send their sales agents and products freely into other states. At the same time, when confronted with lawsuits in those states, some firms sought to hide behind their foreign charter and deny their presence to defeat the court's jurisdiction. And here he's talking about the 1920s when this happened. Lawmakers across the country soon responded. Relevant here, both before and after the 14th Amendment's ratification, they adopted statutes requiring out-of-state corporations to consent to in-state suits in exchange for the rights to exploit the local market and receive the full range of benefits enjoyed by in-state corporations. These statutes varied. In some states, out-of-state corporate defendants were required to agree to answer suits brought by in-state plaintiffs. In other states, corporations were required to consent to suit if the plaintiff's cause of action arose within the state. Still, other states and the federal government omitted both these limitations. They required all out-of-state corporations that registered to do business in the forum to agree to defend themselves there against any manner of suit. Unsurprisingly, some corporations challenged statutes like this on various grounds, due process included. And ultimately, one of these disputes reached this court in Pennsylvania Fire. Now, this is a very interesting case. This is an insurance case where the insurer is doing business in Colorado and it insures a gold mine. Less than a year after buying the policy, lightning struck and the fire destroyed the insured facility. When Gold Issue Mining sought to collect on its policy, Pennsylvania Fire refused to pay. So Gold Issue Mining sued. But it didn't sue where the contract was formed, Colorado, or its home state, Arizona, or even in the insurer's home state, Pennsylvania. Instead, Gold Issue Mining brought its claim in a Missouri state court. Now here's a little inside baseball for you. This probably involved an issue of contract interpretation, and in Missouri they apply a doctrine called contra profferentum. And basically what that thing says is if a subject in an insurance contract is ambiguous, it is construed against the insurer because the insurer had the best chance to make it clear. A lot of other states don't apply such a lenient rule, and that's probably why they sued in Missouri. So Pennsylvania Fire objected and said the due process clause spared it from having to answer in Missouri's court, and the Missouri Supreme Court disagreed. It first observed that Missouri law required any out-of-state insurance company desiring to transact any business in the state to file paperwork agreeing, 1, to appoint a state official to serve as the company's agent for service of process, and 2, accept service on that individual as valid in any suit. For more than a decade, it had complied with that law. It stressed that the law had long permitted suits against individuals in any jurisdiction where they could be found, no matter where the underlying cause of action happened to arise. What sense would it make to treat a fictitious corporate person differently? At some point, this case reached the United States Supreme Court, and Justice Holmes had little trouble dispatching the company's due process arguments. He said under the court's precedents, there was no doubt Pennsylvania Fire could be sued in Missouri by an out-of-state plaintiff on an out-of-state contract because it had agreed to accept service of process in Missouri on any suit as a condition of doing business there. Indeed, the court thought the matter so settled by existing law that the case hardly presented an open question. That assessment was understandable. Not only had the Missouri Supreme Court issued a thoughtful opinion, not only had a similar rule applied to transitory actions against individuals, other leading judges, including Learned Hand and Benjamin Cardozo, had reached similar conclusions in similar cases leading up to Pennsylvania Fire. And Pennsylvania Fire controls in this case. Now, to simplify things and get through this while we're all still young, I'm going to go back and read through the syllabus as it better synthesizes the result of the court action here. Held, the judgment is vacated and the case remanded. This case is controlled by Pennsylvania Fire. Much like the Missouri law that the court in Pennsylvania Fire found to comport with due process, the Pennsylvania law at issue here provides that an out-of-state corporation may not do business in this Commonwealth until it registers with the Department of State. Among other things, Pennsylvania law is explicit that qualification as a foreign corporation shall permit state courts to exercise general personal jurisdiction over a registered foreign corporation, just as they can over domestic corporations. Norfolk Southern had complied with this law since 1998 when it registered to do business there. Norfolk Southern applied for a certificate of authority from the Commonwealth, which, once approved, conferred on Norfolk Southern both the benefits and burdens shared by domestic corporations, including amenability to suit in the state court on any claim. For more than 2 decades, Norfolk Southern has agreed to be found in Pennsylvania and answer any suit there. Pennsylvania Fire held that suits premised on these grounds do not deny a defendant due process of law. It is enough to acknowledge that the state law and facts before the court fall squarely within Pennsylvania Fire's rule. In the proceedings below, the Pennsylvania Supreme Court seemed to recognize that the Pennsylvania Fire case dictated an answer in Mr. Mallory's favor, but ruled for Norfolk Southern because, in its view, intervening decisions from this court had implicitly overruled Pennsylvania Fire. That was error. In this court, as this court has explained, if a precedent of this court has direct application in a case, says Pennsylvania Fire does here, a lower court should follow the case which directly controls, leaving to this court the prerogative of overruling its own decisions. This is true even if the lower court thinks the precedent is in tension with some other line of decisions. Now let's look at the 2 concurring opinions, one from Justice Jackson, one from Justice Alito, and the dissent by Justice Barrett. We'll start with Justice Jackson, and she absolutely nails it on the head here. This is a fabulous opinion written by her, and she writes in a way that gets directly to the point and doesn't waste your time. I agree with the court that this case is straightforward under our precedents. I write separately to say that for me, what makes it so is not just our ruling in Pennsylvania Fire. I also consider our ruling in Insurance Corp of Ireland versus Compagnie de Beausite de Guinée. I probably butchered that, but what the heck, to be particularly instructive. In Insurance Corp, this court confirmed a simple truth. The due process requirement of personal jurisdiction is an individual, waivable right. That was my point. The requirement exists, we said, to ensure that the forum state has sufficient contacts with the defendant such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. We noted further that the interstate federalism concerns in forming that right are ultimately a function of an individual liberty interest, and that this due process right preserves it. Because the personal jurisdiction right belongs to the defendant, however, we explained that a defendant can choose to subject itself to powers from which it may otherwise be protected. Waiver is thus a critical feature of the personal jurisdiction analysis, and there is more than one way to waive personal jurisdiction rights, as Insurance Corp clarified. A defendant can waive its rights explicitly or implicitly by consenting to litigate future disputes in a particular state's courts. A defendant might also fail to follow specific procedural rules and end up waiving the right to object to personal jurisdiction as a consequence. Or a defendant can voluntarily invoke certain benefits from a state that are conditioned on submitting to the state's jurisdiction. Due process poses no barrier to the court's exercise of personal jurisdiction. And she makes the point later on that a lot of times in criminal cases, we permit states to ask defendants to waive individual rights and safeguards, allowing plea bargains to waive a defendant's trial rights and rights against self-incrimination. Moreover, when defendants do so, we respect that waiver decision and hold them to that choice. Which again makes sense. If you're going to do that with, somebody who's arrested for shoplifting, you should certainly do it with a corporation that made $12 billion last year. So then we go to Justice Alito's concurrence, and his is interesting because he says, based on our precedent and international shoe, I'm not convinced that the Constitution permits a state to impose such submission to jurisdiction requirements in its law. A state's assertion of jurisdiction over lawsuits with no real connection to the state may violate fundamental principles that are protected by one or more constitutional provisions or by the very structure of the federal system that the Constitution created. Based on the authority that they cited, that it's probably properly decided, and he'll concur in the result, but he doesn't necessarily concur in the reasoning. Now we drop down and look at Justice Barrett. And here is what Justice Barrett has to say. For 75 years, we've held the Due Process Clause does not allow state courts to assert general jurisdiction over foreign defendants merely because they do business in the state. Pennsylvania nevertheless claims general jurisdiction over all corporations that lawfully do business within its borders, as the Commonwealth's own courts recognize that flies in the face of our precedent. The court finds a way around this settled rule. All the state must do is compel a corporation to register to conduct business there, as every state does, and enact a law making registration sufficient for suit on any cause, as every state could do. Then every company doing business in the state is subject to general jurisdiction based on implied consent, not contacts. That includes suits like this one with no connection whatsoever to the forum. By relabeling their long-arm statutes, states may now manufacture consent to personal jurisdiction. Because I would not permit state governments to circumvent constitutional limits so easily, I respectfully dissent. You can see what happened there, right? The Pennsylvania Supreme Court read Bristol-Myers Squibb, and they said, there has to be some nexus, and there's not really a nexus because the cause of action did not arise in Pennsylvania. There's really no nexus with this lawsuit, and as a result, well, it certainly seems to us that this Bristol-Myers Squibb case overruled Pennsylvania Fire. But obviously, the Supreme Court wants to be the one to decide whether or not its cases are overruled. And while people may disagree with that, the bottom line is that they have the right to keep authority or augment or change authority, and that lower courts do not have that authority to do that. So that's what the Supreme Court held in that case, and instead of clarifying personal jurisdiction, I think it just unreasonably muddles it. Lawyers all over the state went through their state statutes looking to see if their state had a similar consent requirement. And if it did, that would certainly figure into future answers to personal jurisdiction challenges against corporations. It's a good ruling with respect to the fact that you can consent. You can waive a right that you get by statute, the statutory right to challenge this personal jurisdiction. You can waive it by not asserting it, or you can waive it by consenting. You can waive it by consenting, as they held that Pennsylvania Fire did, or you can waive it by just not doing anything about it and failing to raise it. Either way, you have consented to jurisdiction or waived jurisdiction, and you are properly before the court. Jurisdiction is one of those things that confuses everybody, including lawyers, including judges. Judges get it wrong all the time. So if you have any questions, again, I'm not an expert. I'm just a lawyer, a random guy on the internet telling you what he thinks. But if you have any questions, put them in the comments down below, and I will be happy to address them. As always, if you have a question that you'd like to have answered, or a case you would like to have discussed here, send me an email, aldewitt7@gmail.com, and I will certainly consider taking that case up or that question up and putting a video out for you. Thank you so much for watching. I hope you have a marvelous day. And if you have the opportunity today, do something nice for somebody. We'll catch you on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.